Welcome to the STARS program, seniors taking active roles in society. And now, here's your host, Anita Finley.
Very, very smart elder law attorney, Joe Karp. Good morning, Joe.
Good morning, Anita. How are you today?
I'm doing great, thank you very much. And it's we don't know if it's going to rain or not, but you're going to rain wonderful words on us, are you not, today?
Yeah, but they won't need an umbrella if they stay inside.
That's right, they stay inside. You know, Joe, I was reading the article that's coming up in our August issue, and I thought it was fantastic that you talked about guardianship. And I have recently heard of a couple of very bad things happening to people where guardianship took over, even with the family is still around, but the other person of the family went against that family, and that poor person who's being subjected to all this has no power.
That's absolutely true. Now, sometimes it's an absolute necessity when somebody has either done no legal documents and becomes unable to care for themselves and they're harm to themselves or others, can't manage their finances, or even when somebody has prepared legal documents but has not in their legal documents, is not compliant, and you can find yourself in a guardianship. Let me explain, because everybody thinks, well, I've done my power of attorney, and I've done my trust, and I've done my health care power of attorney. Why would I ever need a guardianship? Isn't that the usual question? And the answer is, if the person's non-compliant, when you do some of those instruments, you don't abdicate your own rights to make your own decisions. All that does is give somebody else the right to make them for you, and normally they won't do them unless you're unable to do it. But until you are declared incompetent, technically you can do whatever you want. So if you are your spouse's health care power of attorney, and the doctor says your husband needs to have this growth removed from his arm because it could be skin cancer and it could be a problem, and you say to the doctor, well, just go ahead and do it, and your husband says to the doctor, if you do it, I will have you arrested and I will sue you.
Huh.
You think the doctor will do it?
No.
That's right. Merely because your husband has created an instrument giving you authority to act, it doesn't give you the right to supersede him. So in cases like that, the only way you can supersede him is to have him declared incompetent in a guardianship, and you appointed the guardian or whomever. Now, the good news is this is a rare instance, not a non-instance, but a very, very rare instance. And in most cases, you say to the doctor, because your husband is cognitively impaired, go ahead and do it, and your husband sits there compliantly and does it. The other thing that should have been done while your husband was still cognitive is he would have said, if there's ever a guardianship, this would be in his documents, I want my wife appointed as the guardian. And that would have been in the legal documents, and unless the wife is of questionable competency or integrity, the court will appoint the wife. So that legal document then has bearing. And then under that instance, if she is now the guardian, the doctor can listen to the wife because she has the authority to make his medical decisions, and she is now court authorized. So doing of the documents is not a golden seal. It doesn't mean you are the boss. You know, my little joke is for the men out there, because I am a very compliant husband. What you discover is your wife really isn't your boss. that you do have some legal rights, although I would not recommend you assert them because your wife's usually right. But it's an important thing to know. No. In 99% of the cases, people who have done legal documents, there's no problem. In 1% or less of the cases, there can be a problem where there's somebody, particularly somebody suffering from some form of Alzheimer's or dementia that makes them contrarians by their very nature. So you need those documents, but then you have the pre-need guardian named. The more frequent case is where there are no legal documents in place, where nobody has the authority to handle it. And that's not only health care. I gave the example of health care to show where its ugly head. Normally, the same thing can apply with a power of attorney for property. If your husband is giving you power of attorney to handle his accounts, but he calls up the broker, goes into the bank and wants to withdraw $100,000 from his IRA, it's his IRA. Now, usually brokers and bankers are a little cautious. They do a dance. They try not to, when it smells and they see the behavioral difficulty, they do what they can do to avoid having people go through their money. But the same can happen with a credit card. You could just go online or walk into a store and go shopping like crazy. So those times, again, a guardianship would be necessary to restrain somebody from inappropriate behavior. But most times we see a guardianship when somebody's done no legal documents. They've built in no method for who can take over when they're unable to act or act appropriately in their own best interest, and then you run into the court appointing professional guardians frequently and outsiders. And those outsiders don't know you. Now, some of them most of them, just like most of anybody, are well-intentioned and good and honorable people. But you don't know them, they don't know you, so you have strangers making both your financial and your physical living conditions and health decisions. In addition, there's a couple of bad apples that are out there that have been written up that have abused their authority and made some bad decisions.
Now, Joe, this is a very good time. I'd like to stop you on this because just hearing you talk about this, it is so frightening. So many of us, you and I and my husband and Debbie, we've all worked hard. We all feel that we know what we want and that we expect people, our family members or our friends or people we work with, to do the right thing. But maybe that's just being optimistic. And when it really gets down to it, doing the right thing, it's not that it's malicious. Sometimes it's not what you want. But when someone else can take all this out of your hands and do what they want to do, the only thing that I'm so happy about is that you wrote the article that this has to be taken care of ahead of time. That's the whole point of your article coming up in August. So when someone comes in to see you, do you then talk about setting up something right away so that it can't happen?
You need documents to be put in place. You need to name and designate pre-need guardians. These are appropriate things. Now, and frequently, people have not thought about that. And some people have some difficulty because they are, as I would like to call it, relationship challenged. They don't have good, close relationships that are appropriate to give somebody that kind of responsibility and effectively burden somebody with it. I mean, and then there's the sibling rivalry issues. If I give it to my son, do I give it to my daughter? They can't work together? Who's in charge? And I start to tell them, you really have to tell your kids what you want and who you want in charge and why you want it. And sometimes we help people couch it in better terms. So sometimes those terms are, instead of saying to your daughter, I don't want you to be in charge of my property because your husband is untrustworthy and you're manipulated by him, okay? Because that doesn't fly well for the family politic, even though she may know that. You may say, your brother is more business-like and is better able to handle the business end. Or you can say, as it relates to health care, and this is true quite frequently, you are too soft-hearted. I know that I want my life supports terminated if there's no hope of recovery, and I don't want to be put through a long and extensive ordeal just to be 100% sure. I don't want that to happen to me, and you're too soft-hearted. You wouldn't be able to pull the plug fast enough for me. Your sister would be better able to do that, or your brother would be better able to do that. Or you have too much on your plate to take care of your family. You've got a job, you've got some kids, you've got this. This is more than you can handle. I will not burden you with this. And some people give it to people that are not like their kids, and they say to their kids, I've decided that you will all argue about this. So my sister's going to make these decisions, or my best friend, or whomever. So you have to work it out. But the big thing is to not deny that this can happen to you. I always analogize all of this stuff to some very basic human behaviors that we follow. I would assume that yesterday, everybody who's a listener of your show, yourself and myself included, when we went into our car, we put on our seatbelts.
Hopefully,
right?
yes. Yes.
Okay. And I'm going to hope that none of us had an accident, and that none of us have had an accident in years. That doesn't mean that reasonable precaution of putting on the seatbelt was a bad idea, because every day somebody who didn't plan on being in an accident is in an accident. And with regard to doing these types of estate planning documents, and you know, I'm talking about estate planning for the living, not for the dead. I'm talking about caring for the living. Most of us will never need it. But the horror stories or the inconvenient stories happens to somebody who needs it, who didn't think they'd need it, and ignored the possibility. And it's just taking reasonable precautions.
So, Joe, at your seminars, which I want to talk about next, you do discuss all this. I mean, I know you discuss Medicare and Medicaid and a lot of things, but this is important.
Guardianship avoidance and what happens, and that you do lose control over your life. Now, recognize if you're incompetent and somebody takes over as your power of attorney and they handle everything for you, what you have done is structured who you trust to manage your affairs for you. Somebody that understands what's going on, understands you, and you've made it easy for them to handle that transition rather than have them go into court. And sometimes, and what you should remember, and I always try to coax my clients to remember, that they should sometimes trust the judgment of the people that they raised with their values, meaning your children, than the judgment of themselves that has been declining with age. Because just as your ability to run, walk, golf, hit a baseball, hear, and all of these other faculties decline, it's no embarrassment to come to terms with that some of our thought processes and those judgments also decline. And what I try to get them to understand is that sometimes they should listen to the people that care for them, and that those judgments may be better, although distasteful. It comes to things like, Dad, you really have to stop driving. It's not safe for you. It's not safe for anybody else. And if you're in an accident and you harm somebody, number one, you'd feel terrible. At least the you who was here 15 years ago would feel terrible. You would say, how could I have exercised such poor judgment? You wouldn't let me drive when I'm 14. Why are you driving when you're visually and just your acuity is declined? Two, you could lose your money in that lawsuit if you're sued. So those are hard decisions, but who to manage your money? I mean, who can assist you? Who can help you make decisions? Even when you are competent, just remember, and if you remember, anybody who's raised a teenager or has been a teenager knows this, teenagers are competent. They just make bad decisions all the time because they're teenagers.
Right.
So competent people can make bad decisions, and they're entitled to do that, but one of their decisions should be, who do they want to count on for their sounding board?
Yeah, that's a good point. That's a good word.
Those judgments.
Right. You know, Joe, maybe I ought to give out, I don't want to lose this, I want to give out all the August seminar dates and where it is. So everyone get your pencils out. This is the most...
We'll not be doing one in September. We're not doing it until like the middle of October. So this is
really important.
Last chance.
Right.
The train is leaving the station.
It's coming back, but not until October. So let's get the August ones done. Okay, you're going to go to Port St. Lucie is a wonderful location, as a matter of fact. It's a great place. It has been growing like crazy. So if you'd like to kind of mix it with hearing this elaborate seminar from Joseph Karp and also going and having lunch up there or doing something, his seminar starts at 1:30 and it goes to 4. So that's Tuesday, August the 4th at the Port St. Lucie Holiday Inn. Now,
that will actually be done by Jenny Bernstein, who's with me over 10 years, and she, too, is a board-certified elder law attorney.
Okay. So the next one is Wednesday, August the 5th, from 1:30 to 4, and that's the Courtyard by Marriott, Boynton Beach. And then Thursday, August 6th, from 1:30 to 4, at Palm Beach Gardens, Marriott, and no reservations are actually required. However, if you do want some information about something, you can get it two ways. You can go to their website, which is of course Karp Law, KARPLAW.com, karplaw.com, or you can call 1-800-893-9911. That's 1-800-893-9911. So remember, August 4th, 5th, and 6th. Otherwise, we'll be putting in our August issue that's going to be coming up in another week, all the October dates. So, Joe, you're amazing, Joe, that you have done these seminars over 20 years at least, I think, right? More?
Absolutely. The first workshop we did was April 1994. And I just want to give your listeners a heads up just so they don't think we misrepresented. When Anita said have lunch, that's before the workshop. We are not going to give you lunch. We feed you knowledge, which is the food of life. So come in fed. We give
Sorry, I didn't mean to intimate that. I just meant to go have lunch up there somewhere.
Say,
right.
Anita said have lunch. Yeah,
right.
Have lunch before you come.
Right, have lunch before you come to any of the places. That's why the 1:30 time is very good. It gives you a chance to relax, have lunch, and then go. Bring your friends. Bring your family member. They are so informative, and the time passes very quickly. I think you also always have pad and pencil for people to take notes too, don't you?
Yeah, we have information for them to take home. We have a pad and pencil. We have one other very important feature. For seminar attendees, we will offer them a free consultation if we think we can help them. And for seminar attendees, they can come in and make an appointment, review their existing estate plans because the laws have changed dramatically. This is like going to a doctor for a free second opinion. We have 2 board-certified elder law attorneys. We have 6 attorneys altogether. This is all we do. And we give you a free review of your estate plan to see if it meets your needs. Now, if we think we can help you, if you live in New Jersey, we can't help you. If you saw us last year and you're just a tire kicker who likes to spend time schmoozing, we're not in the schmoozing business. We're in the help you business. So you can't keep coming back and saying, well, I want to know if this is still good. You told me last year it was good. I did it with somebody else. And seminar attendees who, if they hire us to do trust, and we quote our fees at the seminar for trust, but if they hire us and they make their appointment within 2 weeks, are actually given a 10% discount on our fees after the seminar. So that's just another incentive to get people off square one. Now, that doesn't mean they have to hire us. It's a free consultation. But the numbers of people who show up, who meet with us, who realize the services we offer, and that they learn at the workshop that not every power of attorney is the same, not every healthcare power is the same, not every trust is the same, that these things have meaning and content, and you must understand what you have, is very important. And that's how we have built our practice with people who have done estate. We've built it not only with people who didn't have estate plans, but people who had ultimately had estate plans and want them revised and realize that their lawyers didn't follow up with them. We tell our clients every 3 years they're entitled to a free review. We tell clients, and that's important, there can come a time where your husband, whom you love and adore, should not be the person in charge of your medical decisions because he cannot remember anything. You've got to come in with him and have an honest heart-to-heart that he should not be in that position of trying to talk to 3 doctors if you're sick, that your son is the better person to do it, and that your son would respect his father and would join in with his father and talk to his father. We're assuming that to be accurate, and congeal the information and crystallize it and say, Dad, here's the story. This is what we got to do. What do you think now that you know in 30 seconds what the picture is with Mom? What do you think Mom would want us to do? You know, so it's very important. So we develop relationships with clients, which is why we have grown as much as we have. We have grown 2 ways. We have grown not just because we have new clients. We just never lose the old clients. So we keep our relationships going, and we're ongoing, and we respond. I just talked to a client's son yesterday about the trust that we set up for Medicaid planning, where he's the trustee, and we had a 15-minute phone conversation. And when we were done, he said, how much do I owe you? And I said, we don't charge our clients to discuss their trust over the phone. No charge. He said, that's a first. And I said, well, not for us. We've been doing that for over 20 years. That's how we've built our business. We include that in our concept of our fee structure. We want to have the relationship.
Yep. Well, you certainly have figured out how to do something. You know, Joe, you, besides being an elder law attorney, when you first started doing your elder law down here in South Florida, I don't think there were very many attorneys doing this the way you did. And now, of course, we find that that's become a very popular profession, a specialty in the legal world. But someone like you who now has so much experience, and you have a certain charisma, a certain care, that you can't get out of school. You just can't buy it. You can't learn it. I think you just have it, and you do. And so
you have to understand who you are. You've got to be who you are. You've got to incorporate that into your. I was listening to the doctor this morning when he was talking about how he has his motivational quotes for his employees. How
right.
get off your tuchus when somebody's out there waiting to get their blood drawn, and fill out other paperwork later. If what you're not doing is urgent, put it off. Take care of the client,
right,
the patient. And that's exactly it. It's setting a mindset, and you do, as you said to Dr. Mencia, you lead by example. And that's how you do it, and you set it up. The other thing is there's a lot of lawyers who are now saying they are elder law attorneys,
right,
because there's no restriction. If you're not board certified, you can say you do anything. Tomorrow, I could hang up my shingle and say, Joe Karp, divorce lawyer, Joe Karp, immigration lawyer, Joe Karp, I only handle murder in the first degree cases. You could do that as a lawyer.
Right.
You're not espousing that the bar recognizes you as a specialist. You're not saying you're a specialist. Lawyers are licensed to practice law, and they can say they practice anything.
And I'm licensed to do this radio show, and I've just been told we are out of time. Thank you, Joe, so much.
Well, it's always a pleasure. Time flies when I'm talking to you.
Yeah.
Be well, I hope to see your listeners at my seminars this week.
Thank you, Joe.
Be well, and
Karplaw.com, KARPLAW.com. Thank you, Joe.
bye-bye.
Bye.